Trust fund. Trust fund, baby.
Peace, everybody. Welcome to one of the Trust Fund Baby workshops. Today, we will be going over trust funds, trust acquisitions, assets, all things pertaining to trust, and whatever questions you all have, we'll be getting right to it. So, here comes everybody now. So, good. I can start adding people in. That's a bet. Peace, peace, peace. Hopefully, I can get everybody on stage. Bet. Okay. Um. I'm gonna mute everybody because some of y'all got feedback right now. But if you can, I want you all to go in order as far as I just put you all on screen, and please come off mic and introduce yourself. So first we have Patrice.
Hey, how you doing? I'm Patrice. I'm checking in out of Tennessee.
Well, thank you. I appreciate you for tuning in. Do you have any specific things that you are looking to learn today about trust?
I hadn't wrote out any specific questions, but I'm definitely looking for how you're leveraging trust to save on taxes or to engage better with creditors, assert your rights, that kind of thing. If it's helping in those areas.
So you said taxes, asserting rights. I'm just making sure I got this. Why my computer keep doing that? Okay. I got you. So we got taxes, asserting rights, and dealing with creditors, right?
Yep, that's it.
Yes, ma'am. Who is next? Miss Bettina?
Yes, hi, I'm Bettina from Brooklyn, New York. I'm just open to everything about trust, but especially protection, generational wealth.
Okay. Miss Bill, what about you?
Hi, I'm Nakia from Chicago, and I'm just new to all of this trust stuff, and I'm just trying to learn how to establish a trust, what should go into a trust, um, what should you name a trust, just all the basics I'm interested in.
Okay, so you're at the beginning steps.
Yes, I am at the very beginning.
What the trust is, the working components, and the different things that you can do with it. So I'll make sure we'll start there and we'll just branch out.
Thank you.
Yes, ma'am. And if anything pop up, anything as we going through, just either like come off mic, ask question, or either put it in the comments and then we'll go over it.
Okay.
Brother L, how you doing tonight? Brother Chaz.
I'm cool. How about you?
All is well, bro. It's good to see you. I know you've been supporting for a minute. It's good to see you in the community.
For sure.
Is there anything that you looking for tonight as far as the class?
More so just trust administration more than anything.
Trust administration, how to operate the trust, or is it something more like specific that you want to do with the trust?
Operation as well as expressing rights and execution of your rights within trust.
Okay, perfect. That's not a problem. Brother Pickard, what about you, bro?
Learning how you can use the trust in like court cases as in child support and how to get the
So
trust.
hold on, cause I don't got my dry erase. Um, All these trust fund baby pens I got around here, I can't find not a one, bro.
Man,
All right. So we got rights, trust, and you mentioned so pretty much utilizing the trust when it comes to court proceedings, correct?
correct.
Okay. Just making sure I'm not missing nothing from nobody. We got. I don't know why she can't come on, but she in here. Maybe she can see everything. So, first thing we're gonna start off with is one of the presentations that I had made for when I did a lecture back in December. And before we even get to that, how many of you downloaded the 2 trust books that I put in the community? Did everybody get access to those? Anybody have a hard time getting them?
My internet was moving slow.
You said your internet moving slow?
Hell yeah, man. I don't know what Spectrum got going on.
Take off your Wi-Fi and just go on your mobile. Okay, so Riley, he may end up having to drop out and come back in. Let me check comments. Why is that doing that? Okay. So I guess y'all have to do it in a private chat for some reason. They won't let me do it. Okay, Patrice got both books. Cool. I read the one that was 42 pages. I didn't see the ebook, just one. So it was the free ebook, and underneath that book, you should have seen the trustee handbook. Both of those had clickable links that you can access. Only reason why I asked because some of the starter information is going to be a good reference point for you to go back after we get done talking about some of these points. And also just you understanding the language and the words is going to make it a lot easier for you to understand how to operate with your trust. So I do recommend, especially the trustee handbook. The other ebook is something that I wrote or that I just composed in order to give to people when they first starting out. But it talks about the different types of trust, different ways you can use it, the definitions and things like that. The trustee handbook mainly tells you how to operate as a trustee as it pertains to a trust. And some of you are not going to be the trustees of your trust. Some of you will just be in grantor and beneficiary positions. But let's go to this PowerPoint. Is everybody on? Let me make sure. All right. Some of y'all, I don't know if y'all having Wi-Fi issues, but a few of y'all keep dropping off and on. As long as y'all can get access to the recording, y'all should be straight if y'all missed anything. Share screen. Right here. All right. So historical perspectives on education and trust. This is like not the most interesting thing, but it's imperative for you to have an understanding of what you're dealing with, where it came from, and how you have the ability to utilize it today. So, education through the ages, historical perspectives on education and trust. We had ancient civilizations such as Mesopotamia, Egypt, Greece, and Rome. And after that, we have the medieval period. And this is where we got like Montessori and cathedral schools around this time. And right after that was when the Renaissance era kicked up, which most of us remember because this was like really an economic boom. And this is when we had the emergence of humanism. And then we have the Industrial Revolution, which people like me who come from Michigan and a lot of us in America, we know how we benefited from that. But a lot of us don't know that that is heavily responsible because of John D. Rockefeller. He was the one who implemented in the working industry, but this is also a man who has a trust for his own family in order to secure their wealth, even though he created a system for regular working individuals. So you also have to understand these small little things that happen in time and history, because patterns to success is already paved. You just have to be able to expose it, view it, and then align yourself with that same path so you can walk it. Trust in historical context. So we have feudalism and land trust. So during like the medieval times, we had land trust in their role in the feudal society. Early charitable trust for education and welfare. And in the 19th century, there were aspects of philanthropy that was started. We started to see a lot of philanthropy work and people working through trust. And like this is when we start seeing, because of taxation popped up after the 1930s. So you start seeing humanitarian organizations, the Bill Gates Foundation, all of these ways for people to cut taxes by just doing philanthropic work, but also putting themselves in a protected situation. So one of the things that I do teach my students, let me go back and make sure everybody in here real quick, because somebody may need to say something. Okay. I'm about to mute you, Miss Bell. You good though. I just brought you to the stage in case you got a question. You can unmute yourself. Who is Private Trust? Can you come off mic and introduce yourself, please? Oh shit, my bad. I gotta add you to the stage first. My bad. Private Trust, how you doing?
Can you hear me?
Yes. Peace and love. How are you?
I'm great. Peace and blessings be upon you.
Uh,
My name is Aisha.
you said you're Aisha.
Yes.
Okay. How did you? Never mind. I'll sort that out later. But do you have any questions about trust specifically?
Um, I have a lot of questions, but I'd rather listen first before I ask if that's okay.
Yes, ma'am. No, that's fine.
Okay.
So going through the PowerPoint, back to this. Open up the wrong screen. PDF right here. Right here. And the history of trust. This concept originated not as a separate area of the law, rather as a blend of English common law through the Court of Chancery, which was a court of equity, fairness that allowed for a set of loose rules to avoid the slow pace of change and possible harshness of inequity in English common law. The Chancery had a jurisdiction over all matters of equity, including the separate legal doctrines of trust, land law, estate administration, and guardianship. So, just so you know, this is all of this stuff comes from English common law. So, the same country that the United States claims to be independent from, we still heavily utilize their law systems on both sides, the public and the private side, for the equitable aspect. All of the things that we're doing still comes from the crown. So just be mindful of the history of this, because if you ever can't find any of the law as it pertains to trust in the United States, you have to go back to the origins of it. Due to the problems that arose, the law of trust first developed in the 12th century. So now you know when it came about. Trust started coming around in the 12th century. So if anybody ever asks you, when did trust start? 12th century. From the time of the Crusaders under the jurisdiction of King of England, the English common law developed from the ancient Roman law, which regarded property as an indivisible entity. Whoever owned legal title owned all rights and privileges. Hence, one would simply convey land to another full fee title. So, to make it plain, I'll read the second part and then we'll talk about that, because in this section right here, they explain why all of this would even come about. When a landowner left England to fight in the Crusades, however, he would convey ownership of his land in his absence to another to manage the estate and pay and receive feudal duties, with the understanding that the ownership will be conveyed back upon the Crusaders' return. So this is the origin of a trustee, pretty much. Crusaders, however, often encountered a refusal to hand over the property upon their return. So this is also the origins of shady trustees, and we're about to see what they put in place in order to prevent people from doing that, because this is always a concern when somebody gets into a trust. How do I know if I'm not the trustee, the person I appoint as a trustee, they're not going to steal from me or make it hard for me to get my stuff? Because they're the main person who's allocating out the paperwork. They're the ones who's making sure beneficiaries benefit from everything that you're making. They have access to the bank accounts. So it's very important that you understand who your trustee is. But like we're about to read, there are protections for you not to be robbed by your trustee. The disgruntled crusader would then petition the king, who would refer to the matter of his Lord Chancellor, the ones who are over all equity things. The Lord Chancellor could decide in this case according to his consequence, determining that it was equitable or fair. Typically, the Lord Chancellor would consider it to be unconstitutional that the legal owner could go back on his word and deny the claims of the crusader. Therefore, he would find in favor of the returning crusader, because equity is based on just and fairness. So it was his land. The agreement was, you hold this until I come back. He came back. So therefore, this is completely different from the regular United States codes that you understand. Statutes and codes are not based in just and fairness. They are based on commercial gain. And we know that there are laws in place that are not fair. That is not what happens when you deal in equity and you deal in trust law, because it's based on the self-preservation and making sure that people are protected and their human rights are also protected. So this is also one of the main reasons why I favor utilizing trust versus some other business entities, because it's encoded to have protections for justness and fairness as I operate, because you all were asking about your rights. And I heard several of you mention that you want to have an understanding of how this works in court. So if you come in representation of a court and you have a claim against some property and it is said to be yours, you are in the best position possible, because now they have to operate in just and fairness, versus you going through a system that has established that you have to pay for this, you have to pay for that, or because of this code and this code, you technically are guilty, or you have to pay a fine or a fee. And that is part of the issue when it comes to what we know as the legal system. Some of the laws overlap and everything isn't always in alignment. Even though the law is very specific, it's not always favorable to us. Over time, it became known that the Lord Chancellor Court, the Court of Chancery, would continually recognize the claim of a returning crusader. The legal owner would hold the land for the benefit of the original owner, operating as a beneficiary, and would be compelled to convey it back to him when it was requested. The crusader was the beneficiary, as I said, and named land title holder the trustee. Term was use of land was coined in the time developed into what we now know as a trust. So literally, this is how trust came about. Now is no reason for you at least not to know that origin story. Right here, when we talk about protections, rights, trust versus LLCs, just when we look up any court case, the best way I explain this, the liability protection provided in an LLC is not absolute, and certain factors or actions can potentially expose the owners to personal liability, especially because you have acquired these business entities with your social security number. Google government lawsuits against trusts. Tell me what you can find. And for the most part, only time you can breach a trust or even have the proper ability to sue a trust if there is fraud present. So as long as you're keeping clean hands, you're not doing anything fraudulent, there is no reason for you to ever be in court and nobody to even have enough leverage to take you into court. Now, there may be certain situations where one of your businesses, somebody may be injured on one of the businesses that the trust may own, but that still does not bring the trust into court. So we speak on asset protection, conducting commerce, business as evident as trust is the most beneficial and necessary for protection and wealth development, because these are several security exchange cases, and you can literally just go look up all of these cases. They're in trust house millions of dollars for multiple wealthy people. but they never get caught in any security exchange, any government lawsuits because of the regulatory commission that covers it. It's the Chancellery Court. It's not the same courts. If a trust is in place, you go through a completely different court. They call it opening up an Article 3 court. They will do it this in the same exact venue. It's just it's a switch that happened that isn't even recognizable, because once you address or you present that you are operating in this legal capacity, they have to be just and fair. We only got a few more slides. How to transfer assets. So I'm going to come back to that one because I'm going to show you all that after we go through an actual trust document. So matter of fact, let me stop sharing right now. So far, anybody got any questions about anything that you heard?
I do.
What you need?
Boom. All right, so boom. So it's so okay. So when you operate in the trust, as in going against, like me, going against the mother, um, how do we get them to come to chancery court of the trust with the children and the mother?
So you're asking, how do you summon a mother into Chancery Court?
Yeah, like how do I get the jurisdiction to go to chancery court with the trust instead of keeping it in the other jurisdiction?
Okay, so you're asking, how do you open up an Article 3 court?
Right.
So if you go into a court, or if you have a case and you put the documentation on the record, they then have to change the venue. That does not mean they physically will put you in a different court. They're going to have to change the rules and regulatory books that they're going to have to deal with you with, because they have to deal with the trust above everything else, because your paperwork always is supposed to precede you. So if you give them the trust documentation and saying this child belongs to this child belongs to this, and per your most people don't know, I had to break this down when I was on Finesse podcast a few weeks ago. When your children are under the age of 18, you do not have custody. The state has them listed as a ward, and the state is the actual custodian. You have legal parentage, and you are bringing this child up until the age of 18. So the mother doesn't even have custody. And I know that you're the caretaker of your children, so custody isn't really the situation. If you have anything that's coming up, all you want to do is just put on the record that these living souls or entities that came from you belong to this particular trust. And then they have to deal with that from there. Because if you remove them from that said jurisdiction, and also be mindful, if you remove them from that jurisdiction, they're not going to get the same privileges that they used to get if they were getting any. But, my children have tribal certificates and they're beneficiaries to a trust. So I don't have no issues with any government agencies like CPA or anything like that.
Okay. Even if I'm not on the child's birth certificate, the trust overrides that, correct?
You need to make a separate certificate and record it and have it notarized in order to identify you as being one of the parents. Because if it's not on paper, it didn't happen. And you know what they say about the daddy is mama's baby's daddy's maybe. You feel me?
Right.
Even though they look just like you and they're in your house right now. That don't matter, bro. It don't matter.
So I gotta get a certificate of living birth.
It can be a certificate of nativity, or yes, a certificate of live birth. You get it, you list your children's name, you pretty much copy the same stuff that's on the birth certificate, and you just you have it yourself. And you can also send over a copy of that to your Department of Vital Statistics, where the other children's certificate is. And you show them that that's the jurisdiction that the children belong to versus the one that they have, because that's their paperwork. The birth certificate belongs to the state.
Right.
You're just considered a holder in due course just because you have a copy of it. That's all.
Okay.
So back to the trust stuff. Y'all having connection issues. Revocable trust or irrevocable trust? Which one do y'all want to start off with first? Because we have to go over both, because those are the top two categories that everything else is broken down through. So we're going to look at a revocable trust, and then we're going to look at an irrevocable trust. Just which one y'all want to go through first? Y'all can come off mute and speak. Okay, irrevocable. Okay, irrevocable. So are we starting off with irrevocable? All right, let me go into the Google Drive real quick and let me pull one. All right, automations, templates, and we will go over the family trust. Okay, I'm about to share screen with y'all. If you have questions, feel free to come off mic. All right. So this is one of our automated documents in our system. So let me stop sharing really quick. Well, I can show y'all right here. So on the document, there are components that are highlighted fields that get filled in, right? So one of the main things that you have to start off with is the way you name your trust. We just gonna work through the document, right? The way you name your trust. I personally do not recommend that anyone name their trust directly after them. Now, if you have an assumed name or an LLC in your name in order to show separation from the living soul in the business, I feel like that's completely fine. But I do not recommend that you put your trust name in your name, because part of the reason why we do this is to keep an aspect of privacy and anonymity. So only thing I need for you all to do is, it can be, I literally have somebody who named one of their trust Pink Giraffe. You just come up with a name, something that has any form of value or relevance to what it is you're doing, and that's what you're going to call it. And keep in mind that you can make multiple trusts. There is no limit to how many trusts you can have. There's no limit to what you can put into your trust. Those type of laws or restrictions doesn't apply to these type of structures. Now, the grantor name, the settlor, grantor, trustor, creator, these all names are synonymous. So the individual who is granting the power in the trust, and also who is the one who came up with the aspect that we need to have a trust, that is one of the first parties that you have to know about. So we have three parties: grantor, trustee, beneficiary. Next party right here, trustee name. This is going to be the one who has the ability to open up your financial institutions for you. They will be able to give dividend payouts to your beneficiaries. They'll be able to move property around in it. They'll be able to put things in and out of the trust. Also be able to appoint other trustees so that other work can be done. So my CFO is one of my trustees. We have relationships with multiple financial institutions, and I can have her appoint Fidelity to be the trustee for one of our accounts. She's still the main trustee, and she can appoint Fidelity Financial Institution to be a successor trustee in order to manage and do some of our brokering for some of our other accounts. And it says that within the trust structure. So trust creator name, once again, grantor name and creator name is synonymous. So when you see this, especially in the trust book that I gave you all, it literally lists that trustor, successor, trustor, settlor, creator, and grantor all are synonymous terms. They mean the same thing when it comes to this particular structure. These are already notarized too. So trust name is repeated. Oh, trust ID number. So this part right here, the trust identification number for our members, this is usually their EIN number, but you can generate your own 9-digit number. You can make it yourself. you can use a registered mail number, but we make the trust ID number. The trust ID number can be different from the trust EIN. We just use the EIN as the ID number. So it's less numbers that we have to keep up with. And we can take the document straight to the financial institution and get it open. One of the main reasons why we do use this is structured like a business trust. So when you see the legal language inside of it, but it says the word family because financial institutions do not favor opening bank accounts for business trusts because they know that it's harder to tax them, especially if you're knowledgeable of how to create a proper structure. Family trust executive trustee appointments. So this particular document, all you're doing is listing who the trustee and what you are utilizing. Is this no? This not the one that has the funding. Yeah, this is just the trustee agreement that they agree to uphold everything, and they sign this and they do the acknowledgement. It gets notarized, right? And then you have your consideration and certification. When you see consideration right here, it says that we have tendered over a specific dollar amount in order for us to be able to certify and validate that this is a funded trust. So, I have a silver portfolio. We usually use actual lawful money because we keep our trust in a common law jurisdiction versus us dealing with the fiat system. Because when you deal with fiat, you are dealing in different jurisdictions. So that's more so the legal realm with the statutes and codes, IRS taxation. The only lawful money is gold and silver. So in order for us to have a lawful trust and also be able to tender things over for land, we make sure we use lawful money. That's not mandated for everyone, but that is a clause that we put in the trust in order to, protect you as you move forward. But I do recommend you do start collecting your pieces of silver. You can get them before the price went up for gold. I don't know what it is right now, but I know some of our silver dollars. I don't have my wallet in here. I don't have no pieces around me, but some of the pieces is like $30 to $40 per piece. But these are assets which can become leverageable, and you can also resell them at any point in time. It's just like having a watch. Contract and declaration of family trust name. So right now we talk about the jurisdiction and the governing law of the trust. In this section, and it also says right here that this is an irrevocable trust. So we list out the points that makes it irrevocable. If you do want to become knowledgeable in how to structure out your own trust, and these are the parts that you have to make sure that you implement in. So you see the whole section 1, Article 1 indenture. They're going underneath jurisdiction governing law. Y'all can be able to go back and see the replay if y'all ever want to redo this. But this is the trust that I give most of you all. So when we see, and also the language in my trust is not the same as if something you will see on Google because we know better. So we change things and we make them better. Like literally right here, the trust organization shall be originally domiciled and shall be interpreted to be constructed under the laws of equity. And this one says the rights of indigenous people. This one specifically was made in order to work in favor of tribal, American Indian aspects for taxation purposes, and also to just be tried an aspect of just and fairness, because it says this is the jurisdiction we operate in. If these parts aren't in here, usually most people fall underneath state jurisdiction because some people like the jurisdiction is Michigan. So whatever laws that the state of Michigan have put on top of trust laws, you will be bound to. And they can do that because the fact that they've adopted these laws and underneath their own constitution, it gives them the ability in order to superimpose certain things in order to create aspects of what they believe is just and fair for the rest of the citizens. But it's usually only if they find fraud in the trust that they even have the ability to do that. Expressed intent, appointments, definitions, Article 2, this goes over trustees. All of this stuff is when they're saying that the trustee can hire other people, how the trustee gets paid out, who the trustee pays. This language is super important because if you're missing some of this part, you could have a gap in your trust that allows you to get robbed just because you just didn't have the protections in there. But there are laws that say that people aren't supposed to do anything. But if you give your trustee the ability to appoint themselves as a beneficiary, and then they're able to get money because they did that, not to your knowledge, because you haven't looked at any of your documents. They're not doing anything illegal because they're listed as a beneficiary. So that actually happened to somebody on their trust. And when I had seen that the attorney was listed as a beneficiary, I asked them why. They didn't even know, because they didn't even read the documents. It's important that you go back and review these things for sure. Successor trustee, that's if you have a second trustee. Removals of trustee, people get fired every day. It'll be all right. So sometimes just people can't cut it, or you may need something done in another state. It may be more feasible for this person to do it, or you just may create another trust in order so that you can just have this one person handle this one business operation. You have the legal ability to do that. And nobody, this is a tip that I've had to do before. I've literally had to recreate the same trust and change out my trustee just in order for me to be able to go open up this bank account here, or be able to go do this deal over here. But the whole structure stayed the same, and I never did anything illegal. I literally just mirrored the already existing trust and changed the trustee for that particular relationship. Now, it's always based on what your personal needs are. But like I said, so in some cases, I have two of the same trusts. Officers, agents, beneficiaries, certificate holders. So when we start talking, a trust is allowed to have up to 100 trust certificates. Now, what the monetary value of that is usually based on the assets and, you know, how liquid the trust is. So if you have $1 million, it'd be $1 million divided by 100 will be the price of each share. You feel me? Trust certificate is literally right there, 100. Let me scroll back up. And this is standard across the board. I have never seen a trust, nor in the law does it say a trust can have anything over 100 units. So trust total issue should be 100 units in accordance with the exchange property, and the settler of 100 units shall initially be issued and owned by the settler. So as the settler, creator of the trust, you are the one who allocates out the shares to the beneficiaries through the trustee. So if I want somebody to actually hold value in the trust, as we start putting the company, so we put Trust Fund Baby in the trust, we put Game Face Growing Farms in the trust, the cannabis company, we put the podcast into a trust. All of these incomes are coming into the trust. If I give a share or a unit, technically from the income that goes through this trust, I'm setting them up for a dividend payout based on what their share price is. And this is how I know who gets the benefits, because you can be a beneficiary and I don't have to give you trust units. As the settler or the creator of the trust, I can maintain them all and just have it set to where when anything happens to me, it gets dispersed to the beneficiaries. But it's levels that you can structure out these things. But it's not necessary for you to operate through these units, but it is something that you should learn how to utilize, because it is to your benefit, especially if you're going to be doing anything with real estate when it comes to the trust, because you can have a REIT, a real estate investment trust. And if you want to bring in equitable partners in order to invest more, you can give them shares of the trust in order to operate as equity, right? So it's almost like doing like an IPO, but just with a trust, initial public offer. Privacy, duration of trust right here. This is one of the last things I want to make sure y'all seeing. Average trust expires between 15 to 25 years, right? Right here it says this trust shall continue in perpetuity from the contract date, right? The trust should be terminated at any time pursuant to Article 2, Section 2.62A. So this is another reason why you just can't copy what I say, because you actually need to know what my Article 2 says in order for the clause to even be in place for the trust to be terminated, because I just said it doesn't get terminated, but there is a saving clause that allows for you to do the termination if necessary, because like I just said, I had to mirror a trust. And if I wanted to wind one of them down or terminate it, I have to implement that one clause in order to make sure that the trust was properly closed. Continuation of trust, trustee board, trust board, trust funds, records of trust. And because this is an irrevocable trust, once again, this is the section I need y'all to see. We have other trusts, like we have blind trust, We have blind trust. We have trust that we use for surety, which is trust that we use in order to transfer debt away from creditors. It's pretty much like a debt collection agency comes in place and does an acquisition on the debt. And because they have acquired the debt, it's now on their books and their asset list. So the debt acquisition company will actually just be the trust. So the trust will come buy the debt on behalf of me. So instead of this belonging to me, the trust then comes and takes this responsibility. And per fair credit reporting laws, if the company that holds the debt, if they don't choose to request it, they don't have to report it. So if something that you control owns your debt outside of you personally, your social security number, it is up to you if you want to request for yourself to pay that back, the same way how a third party debt collector does. When you understand how the system works, you understand how you can implement it and utilize it for yourself and leverage. Same thing when it comes to the wealth building triangle. This is why we use 3 trusts in most cases. We have a Trinity trust. We will use a family trust, a business trust, and a charitable trust. The charitable trust, in order to take on the donations from anybody, and even me myself, if I had acquired any tax liability throughout the year from any of the acquisitions, I can just donate to my own charitable trust, and then I can give myself a tax break. Remember, I'm not the one down as the owner on any of this stuff. It's a trust. But I can offload taxation by running it through the charitable organization. And then that means these donations, which the charitable organization brings in, can, whatever it has to take care of, as long as that's done, everything that's left over can be legally allocated out to the beneficiaries of the said charitable trust. So if you are listed as a beneficiary, you have just created an avenue in order for you to run the money. Let's say you need to leverage some finances, you need to show that you're liquid with one of your financial institutions so that you can pull a line of credit. So we'll take the money from the charitable organization and we can have the charity give it to the business, because we can contract for that business to do something for the charity and then pay it. You just have to create the infrastructure in order to create the money flow, because now we've ran cash flow through this particular business entity, well, this trust. And now the financial institution is going to trust us enough in order to give us a line of credit. But this literally can be done with the same $10,000. I donate $10,000 from my family trust, donates $10,000 to my charitable organization. My charitable organization will contract the business to do some consulting that may cost $10,000. And then now what this is legally called is tax avoidance. Tax avoidance is legal. Tax evasion is illegal. Now, because you can structure a system in order to move the money, this is the same thing every wealthy person does. Don't get it twisted. Now, when you start laundering and you start taking dirty, illegal money and doing things like that, that is when you get into a whole nother situation. And that's not what I'm teaching y'all here. But asset transfers. So right here, this is why we about to have to go back to the PowerPoint. Y'all see the Schedule A, right? Schedule A is a section. I should have opened the other trust so y'all can see that. PDF. Okay. So when we come up here in the Schedule A section, this is when we get over into asset transfers. Keep in mind, everything we're talking about is an irrevocable trust right now still. Create a trust. This is how you do the asset transfers. I listed it out in the PowerPoint. You create a trust. You identify the assets for transfer. So one of the assets that I may want to transfer to my trust, let's say I'll use my necklace. I'll transfer my necklace into the trust, right? My necklace has a serial number somewhere on it or an inscription. So I'll take the serial and I'll write it down, and I'll also detail what the description is of the trust. And I'll also I'll detail the description of the change. And I will also put the monetary amount of what it's worth right now. And because the price of gold then went up crazy, the price for the necklace actually went up. So I'll put that there. And so I've identified the asset. And by me identifying the asset, this is for something that isn't controlled by something else. I'm going to tell you how to do it with houses and cars as well. So I literally would just list it. I'll take Trust Fund Baby Chain and I'll come right over to this trust agreement. And I'll just like TFB Chain Gold dollar. I'm not gonna put the real number, so we'll just say that. And right here, technically, I've itemized something into. This is as simple as it is as an asset transfer. This is how you list things in your trust, and this get notarized at the end. And if any of the things are listed in the Schedule A, if any beneficiary is in the trust, the things get divided between them. So beneficiary section goes right here, right? All this gets notarized. So if I have a, let's say, because I had a F-250, I had a F-250 lifted with Rams. All right, so this car right here, I will put the VIN. I'll do my VIN number. I'll also do the color. It was blue and black. Okay, blue and black F-250 with the VIN number. And now, since it's on the trust, now what I do, let me take y'all back to the PDF. Okay, now what I do, I've identified the asset. The asset in this case is something that I have to deal with another entity in order to do the transfer, such as the Secretary of State or the DMV. Now, I've identified the asset. We've documented what it is, the identifying number, the VIN number, right? We put it on the Schedule A. Now we have to update the ownership documents. For various types of assets, you will need to update ownership documents to reflect the trust as the new owner. We did that in the trust, but did we do it with the department who seized the car? So did we do it with the Secretary of State, with the DMV? Not yet. The process differs from different types of assets. So that says real estate, bank accounts. I didn't put cars on here. That's crazy work. I swear I thought I had it on here. Thankfully, I'm about to tell y'all. Okay. So you go to the Department of Motor Vehicles and you're going to ask them for a title change. That's literally the only thing you're about to ask them. Can you update your title? And when you get the title, you're going to request, you're going to write down that the trust is buying the car, and whoever the trustee is on the trust, you're going to put them down as the trustee. It may be you. So you'll put your name and you put TRSTE, right? And then you also be mindful of the price you say that the trust got the vehicle for. You can gift it. You can gift it, which I recommend, because then you won't have to pay taxes for that said transfer. But the moment that they say that the trust is the owner and then they give you the new registration and stuff like that, that property has just been completely transferred over to the trust. Because within the trust document, which you can record in the courts or not, but you have to take your trust to the Secretary of State or the DMV in order for them to even see that it's listed in there. But in most cases, they only ask you for the cover sheet just to ensure that it has the trust. It is a fully legitimate trust, that it has the 9-digit identifying numbers and that it is notarized. And then they just do the transfer for you. That is how you do it with the car. Now, if you want to do it with a house, you have to go to your county clerk. You go to your county clerk and you have to update your deed, whether that's a quit claim or however, whatever type of deed structure you have to now go in and say, instead of it being you personally or whatever business it was previously, that is the trust. And you go into the trust document and you list that property with the means and bounds, longitude, latitude, and give property description of what the house is. And technically, that's as simple as a property transfer goes. Yeah, and that's
Question.
Go ahead, fam.
Okay. So when you transfer, okay, say you still paying on the car, right?
Mm-hmm.
Or the house, and you transfer it into trust. The trust now owns the debt and you don't, correct?
Okay. You said most cases, you will not be able to transfer the debt with the lien being still in place. You will now Have you, and best way I can explain it is if you sell your car before, like if you sell your car to your homie before you finish paying it off, you know how some people do that. Like, I don't want this no more. You can buy it from me, right?
Right.
In a situation like that, yes, but you have to communicate. And that was something that we had said on the PowerPoint that I didn't even touch on. You have to communicate with the financial institution in order so that they can update the documentation. So all you do is tell them that somebody's stepping in and they're buying a contract or they're buying whatever property it is. You have that right. Now, they also maintain the right to not contract with that previous individual, but you also have to understand the control you have when it comes to contracting. Being the holder in due course of the contract, remember, these contracts can't happen without you and your social security number being in place anyway. So you are the one who have all of the leverage, right?
Right.
Yeah.
Okay. So they got that right to whether they want to whether they want to contract with the trust.
Banks, financial institutions have the right to stop doing business with anybody if they so choose to. Now, if you are in contract with them, unless you breach said contract and they just decide to terminate contract, it gives you, most people just don't know that they have the legal ability to go back and, like trip out on them. Because I know several people who have had bank accounts closed and didn't know that they can go have them open back and go do tax credits and everything on all them transactions. It's just we don't understand our role as consumers when we are doing commerce, and we still have yet to learn our role in the private sector as well.
Okay.
That answer your question?
Right. Like halfway. But say they do accept the trust, then the debt goes to the trust.
Yes.
And
Yes.
that means and that means in your credit report, then that means it's paid off in their eyes.
No, that's
Dang.
not what that means. It doesn't mean that the debt is paid off in their books. It just means that the debt has been acquired by another business entity. So this is, look at it like a third-party debt collector. You don't pay your bill with Amex and they charge it off. They send it to a third party so they can still get some type of money out the situation, even though that they're going to do their taxes on it, right?
Right.
It's the trust in this case will be the third party that's stepping in and buying the debt, bro. That doesn't mean the debt is dissolved. It's just that entity has the legal ability to decide if they want to press you for that money or if they don't. So I literally, and then this is another thing that people don't realize. Debt is listed as assets on a ledger. So if I take everybody debt on here, right? And I just say that one of my businesses owns all of y'all debt. Let's say it come up to like, I would hope not, but like a half of M, right? Because I have the ability in order to leverage or either request this debt from you all, a financial institution will give me a line of credit for almost 80% of that debt portfolio.
For real?
Yeah, people about
so whoa. This next level right here. Whoa. So if the assets hit the trust, now you can leverage the assets for a line of credit.
I've been telling you, did you see the podcast I did with Finesse? I kept on saying, you've heard me say this because I mentioned it. I'll be like, credit is a broke man's game because They don't give that to wealthy people, bro. They allow wealthy people to do collateralized lending. So if you have a trust and you have assets based on the collateral I have or based on my financial relationship, how much money I'm running in and out your account, you're just going to give me a line of credit. No credit check involved. Like I told you, bro, who's running Donald Trump's credit, fam? Who's running Barack Hussein credit? Who's running Jeff Bezos credit? Nobody's running these people's credit. Based off of their asset portfolio, they're able to get whatever it is they desire. That's called collateralized lending.
Dang.
Okay, I'm about to catch these questions right here. So, Patrice, you said, do you register the trust with the IRS and the state? The trust does not get registered with the IRS. What you're doing with the IRS is you are filling out an SS4 application for an employee identification number, and it's usually for banking purposes. That is not considered a registration. When you do registration, legal definition of registration is to overturn ownership, and that is why some of the reasons why people do not put their trust into some of the county recorders and records. But It's not necessary for you to register a trust in order for it to be legal. But if you want to bank, you do need an EIN number. Now, the main thing that makes a trust active is after all the signing parties, everybody has signed, it's been notarized. That's usually the main thing that they look for is the notary presentment. Ms. Bell, you established a trust. Do you need to notify anybody that you have one? Yes, you need to notify the parties of the trust that you have a trust. Your grantor, creators, if it's not you, whatever business entity or whoever it was, your trustee and your beneficiaries. Anybody else outside of that is not their business. That's your private business for your family assets. Now, if you want to ensure that certain people get certain information and things stay out of probate, yes, record it into the courts, especially if you got land and stuff on county records. That way, if anything happened to you, nothing goes to probate. There is no question. But you also want to ensure that the people who are a part of your trust have a copy of the said trust. Because how am I ever supposed to prove that Michael Jackson left me $1 million if I ain't got a copy of the paperwork? Who's going to give it to me? People going to look at you like you crazy. And that's why the main reason why we got to make sure they have copies of the documents. How often can you add things to the trust? Whenever you want. The way I do it for y'all, I don't fill out y'all Schedule A unless you request it, but y'all can literally write that stuff in with a pen because it's notarized. And if you have to make any changes or any adjustments, everything is already set so that you can do it. But I do my best to make it simple and keep in mind, like somebody just reached out to me because they just had another child and they was like, I want to add somebody to my beneficiary list because I typed theirs up. They could have just wrote it themselves if I left a Schedule A blank. But one of the things I started doing was leaving the Schedule A blank and just teaching y'all how to fill out it yourself. So if there's anything that ever comes up, you can just write it in because the document is notarized. It's already solidified. These are cheats, I'm telling y'all. This is not the way it usually goes. I just want y'all to know that because usually once it's notarized, whatever is on it is on it. But because I'm your notary and you're communicating with me, I can affirm and attest that these changes are valid. Like that's how a notary presentment works. Because as long as you communicate with me and I'm like, yeah, I'm like, it's no problem, fam. It's no problem. Even if you need me to change something, it's not a problem. So really quick, do we need to go over what a revocable trust looks like? The only thing that we possibly did not touch on is the spendthrift clause. Let me see if I can find a spendthrift clause for y'all really quick. The revocable trust, the only difference is it's easier to take things in and out of. So this is a revocable right here.
So hold on, wait a minute, bro. So the family trust you got me,
It's
I can
irrevocable.
go in it. Yes, you said it's irrevocable,
Yes, sir.
but I can still go make those changes, can't I?
I just told you how. If you need me to do them,
Well,
because usually in an irrevocable trust, whatever is in it stays in it. But
right.
so this is also the reason why you have to realize what happens when you record the document. If you take your documents and you record them in the court, right? You're
Right.
pretty much saying this is complete, this is done. And because this is an irrevocable trust. Now, before you do that, you can change everything up until the point where you're like, this is my final trust, this is my final will and testament, and this is how I want everything to be. I more so recommend you move it like that versus you just going to go record in the courts right now, unless you are dealing with forms of land acquisition or real estate, because it will give you the ability in order to still make the the changes you need. Turn your music down, bro. You good? All right, so let me show y'all the spendthrift clause really quick, and that way we can break down this because you all asked about protection. We went over rights, trust operation, which was the basic components. The court component when it comes to trust, the biggest thing is just making sure that you have it on record, fam. Making sure that you have it on record because then that forces them to deal with the trust, but also whatever's in your trust structure matters. Creditors, spendthrift clause. Give me 1 second. Let me just search spendthrift. This is their. I'm about to share screen with y'all so y'all can see one of the revocables. You still running the streets, Riley? All right. I'll go to the top real quick. Revocable living trust agreement. Is this the right one? Mm-hmm. This is. Power of attorney. Provisions. Residence. Durations. Elections. Disclaimer. I just finished this one the other day. We did some changes on this one. I'm trying to remember where the spendthrift clause is. I may have to just pull one online for y'all. Successor trustees. Compensation. That's trustee payment. Dealing with trustees. Business manager. Or is it in blind trust? It should be in this one. Trust estate, general powers provision, Article 4. I read so many of these documents. Taxes, debt, collection proceeds. Right to revoke, man. Yeah, this is way too high. It's not right here. So let's just pull it. Spendthrift clause. Let me see if I can pull an example. Okay, y'all can see screen, right? Spendthrift clause is a provision in a trust that protects the beneficiary's assets from creditors. Main thing you asked about is how you protect yourself from a creditor when you have a trust. It is called a spendthrift clause. If your trust does not have a spendthrift clause, you do not have creditor protections. It's literally that simple. Here are some examples of spendthrift clauses. Adrian creates a spendthrift trust for his son who has a gambling addiction. Carl receives a monthly income from the trust but can't take a loan against the trust assets. So if there's a clause, he gets dividend payouts, but there's a clause saying that he's not allowed to take out loans. So he literally gets a monthly allowance from the trust in order to manage his spending habits because he has a problem. And do you see how that it's like giving somebody just enough rope so that they can move but not hang themselves? This is how you create security and protection. P creates a trust with a spendthrift clause that pays Junior a set amount annually. Junior creditors cannot seek a payment directly from the trustee or attach interest to his future distributions, which is pretty cool. So clearly they can't press your trustee either with the spendthrift clause. And just think about this. If you transfer debt to a trust and they become mindful of this, if you are listed as the beneficiary, that still does not give the creditor the ability to come after you. Now, if it's just you and your social, they have every right to keep on pressing you and harassing you. So you see the imperativeness of being able to make the change of that. And I showed you how to do the asset. Debt is also, I told you, debt is also considered as an asset transfer. So if you can learn how to communicate with the creditor and get them to change the name on that bill over to the trust name, you've already done the majority of the work. Because now when they reach out to that entity, they can't come after you directly because you have a spendthrift clause in said trust. Now it's just up to whatever the trust decides to do at that point when it comes to that relationship of that new contract they have acquired. A son with a credit card debt is a beneficiary of his mom trust with a spendthrift provision. As long as no money has been distributed from the trust, the son creditors cannot look into the trust to satisfy his debt. That is crazy though. But see, it's different spendthrift provisions. So as long as no money has been distributed from the trust, the son's creditors cannot look to the trust to satisfy his debt. So this may just be a holding trust. And also, this is also one of the other reasons why you do not desire to do public recordings with your trust. Because if they do, what is it? When they do one of the public search pools, if they do one of them on you and they see any of your public court records with your name, they can see that you have just gave up the majority of your assets and list and things like that. So this also makes it a little bit easier for people to try and sue you personally. Because of things, it doesn't mean they're going to win anything, but doesn't mean that they're not going to stress you out and try and keep on putting you in court. Some people slip up and they end up having stuff in a personal when they still have a trust. But if a creditor finds out that you have made it difficult for them to get to you by operating through a trust and they still know your personal name, there really isn't nothing stopping them from them trying to take you to court underneath your personal name again. Only protection you will have is the fact that you now don't own anything. The trust owns it all. So you technically will be legally considered insolvent and you can't pay them anything. So that is spendthrift clause. Questions. One second. I'm trying to make sure I got all y'all in. Okay. So anybody got any questions about anything so far? Because that was the main things that y'all asked about. I know it probably didn't seem like I touched on what y'all asked, but I really specifically gave y'all the answer like the best way I could. What y'all questions say? How much do you charge to help structure one trust? Also, what happens if you put your will in probate instead of a certificate of deposit for safekeeping? How much do you charge to structure? If somebody is a member of the community, they get a discount on the trust. If not, our starting price, depending on the trust structure that you want, starts at $750. And also, what happens if you put your will into probate instead of a certificate of deposit for safekeeping? I am not somebody who favors wills because I don't desire for any of my stuff to go to probate. That's one of the main reasons why I use the trust. And a certificate of deposit for safekeeping. SKRs or any certificate of deposit. I will only do special deposits if I want to do some safekeeping. I wouldn't. And yeah, if you want any SKRs, should always be a special deposit. That way, any safekeeping. When I say SKR, that's safekeeping receipts. You should always do a special deposit instead of a general deposit because you want to be able to get the same thing back that you put in. So if I give them, I really don't got none of this money laying around here. That's crazy. If I give them a silver coin, I want them to give me back that same exact silver coin pre that 1800 Liberty coin. I don't want you giving me a 2024 Liberty coin because it doesn't have the value. So you also have to be mindful if you're doing certain deposits, that does not necessarily guarantee the safety of said deposit. Always make sure it's a special. But if you got more questions, feel free to reach out. And also, the community is free if you just want to ask questions in there. How do you file taxes with your LLC once you put it into a trust? If the trust owns the LLC, the trust is responsible for the LLC taxes at that point. The business itself can just file its taxes, but you wouldn't be responsible if it went default. All of that liability will go directly to the trust. So if you want to do something like that, you have to update your articles of incorporation, your bylaws in the state that you registered it with, and you already need to have a trust. And I recommend, because of FinCEN and beneficial ownership laws, the trust should own 100% of it, and then that will put you in an exempt filing situation for the laws that they implemented January 1st of 2024 for you having to report. Yeah, that should be it for that. Can you add your car if you're still paying a note? It is up to you to deal with the financial institution and communicate to them that you want to sell that car over to another entity. Now, because financial institutions know how trusts work, they may give you a really hard time when they find out you trying to transfer it into a trust and you still haven't paid it off completely. There's other ways in order to satisfy that. In all honesty, I would recommend that you all understand the aspect of how debt works in the United States. The United States is responsible for all debt. And if you understand how the coupon voucher system work, and also in the credit report, in the Fair Credit Reporting Act, in the Fair Credit Reporting Act, it literally says that discharging of debt is an actual process. So when you understand that when you read your payment agreement for a coupon and it says that you're supposed to send a coupon in, I literally just had one of my people, I believe it was a power bill for $2,600 or something. I think they may grow cannabis or something, but that's why their bill was so high. But they just paid their bill with a coupon. So I would much rather you get to a point to where you can settle the debt with the negotiable instruments that the entity has given you, or you challenge the contract. Is much better to settle the debt because you can get the money back in taxation. So I recommend you get educated in that, because they're not going to make it easy for you to do the transfer with the lien, because they're not going to want to release the title. It's other ways to do it, but in all honesty, the easiest way in order to manage any form of debt is understanding how to properly pay it, or properly shift the funds in order to discharge the debt. Let me say it like that. So if you got a new car, try and get it in the trust name instead of yours. Yeah, it's nothing saying that you can't go onto the lot and go buy your car in your trust name. I'm taking Goody class on that. All right, cool. That's what's up. Yeah, so you know exactly what I'm talking about. She explains the bill remittance, the billing error, and then even I teach UCC law and the contract law, so you understand how you deal as the holder in due course. You understand the financial triangle when it comes to you, the merchant, and the actual bank. I'll tell you all this because I have to explain it to other people several times. If you ever get an Amazon credit card, Amazon contracts with Chase. So it's me, Amazon, Chase. The same homie who that's what it was. It was an Amazon card for 26. He sent the coupon voucher to Chase instead of to Amazon, because you also have to realize that these financial institutions, they contract their financial services to merchants, and you deal with the merchant. These are 3-party contracts, and you can always just go directly to the bank, because the bank has the ability in order to settle and discharge debt because of their relationship with the United States Treasury. You let them handle all of the transactions, but it's not as simple as I'm saying it. You also have to know the proper amount. You have to know where to mail it. It is simple when you think about it, but I do recommend y'all learn about that because it's more fact than fiction. And one thing I can have concerns over are bills. It's just never really been a concern because I've been doing stuff like that since my early 20s. Amazon Chase, coupon voucher to Chase. Yeah, that's exactly what he did, because the financial institution that the merchant operates with understand what you're doing when you send the coupon out, and upon acceptance, if you're going to resell or you're going to renegotiate. I have to deal with the banks. Yes, it is. You don't have to. This is why you still have to read the payment agreement. Is different with everybody. And even if you get into a position where you have initially went and got credit in your own personal entity and you want to transfer this over to the trust because you don't want all of this information to be in your credit profile, right? you have to read your payment contract to see what's even possible to do that level of transfer. Because keep in mind, all of these credit transactions are based off of your social security number. So the moment you change the EIN, you also change the financial structure that everything is attached to. And if you, so just be mindful of that. When you start taking things away from the social, you also are stepping outside of that structure that they made that has that debt safe haven in it for you to just be able to discharge things. It doesn't mean it's not possible with businesses. It's just, it's a little bit different because if things are based off of your social security number, and this is how you have the ability to do it. But also in law, it doesn't say it's just for personal debt. It says debt, period. You just have to understand the relationship of how it works with a trust in a business versus you personally, especially if you still want to be claiming tax credits for some of these transactions. Right. Do I teach it also? I don't care to teach it. I teach the structure around it. Main reason why I don't teach it is because I don't want to be responsible for somebody ruining it for everybody else. Because so we really almost have to be on a one-on-one phone call for me to break down some of these things. Like in a class setting like this, I wouldn't go over some components. I'll tell you the laws and the things you can read and understand so that you can figure it out. Outside of that, like only on one-on-one calls, I told somebody how to do it on the phone call before we got on here. But on video is different because I deal with other financial companies and tech companies. I have to be mindful of what I allow to live on film and on camera because this is actually going to be uploaded to YouTube, even though it's unlisted. So the back end of YouTube will still have access to this video, and y'all don't know because y'all don't know what it's like to deal with financial institutions and they give you a non-disclosure agreement and you can't say stuff. So certain things I'm not in the position to talk about on camera to everybody, but it doesn't mean that on a one-on-one consult, I can inform you and direct you to the right direction as best as I know how. And if I don't know, I do know the resources and also other people who have done things that I haven't done. So it's always about networking. What do I charge for a one-on-one? In all honesty, if you in the community, all you have to do is reach out to me and I'll set time aside for you. I'm like, you can ask anybody. I'm not funny like that. Or you can literally just ask the question. If I'm available, I'll probably just get on the phone with you. I've always been like that in almost 10 years, man. So that's the gist of the class. Please make sure y'all get both books, review the information. If any of y'all who are in class right now, if you need a trust from me, it is half off because you're in the community. If you're in the community, all services are half off. So all you have to do is let me know. If you want to attempt and do it yourself, let me know. I'll review whatever it is you come up with and I'll let you know how to direct it, change it, or whatever. You don't have to pay me. My goal is to make sure that you get it right. So, questions? If y'all ain't got no questions, I'm about to go. I ain't gonna hold y'all. My homie is trying to get me to go to the strip club tonight. I honestly don't want to go. I don't like going, but I can go. How do we watch the recording of this? Okay, so in the community, in the paid programs, that is where the courses will be. If you are not in the community and you pay to be in here for a drop in, I'll just send you the unlisted YouTube link so that you can get access to it. You just have to, after we're done with the class, I have to send the video over to my tech, and then he's going to upload everything up in the school. Oh, you mean in the community? That's a bit. I got you. So, like, fam, I'm telling y'all, please ask me questions. Y'all can come off mic and ask. Whatever is in the back of your head, just ask it. It's not no dumb questions when it comes to this, fam. I just want to make sure that I am providing y'all value.
Okay. Well, can we get started with some coupons?
That don't got shit to do with trust class, bro. Don't know. That don't
Oh,
got shit to do with tonight.
I
And what
thought
I
you
just say about me teaching that.
meant, nah, I was talking about one-on-one off the camera because of disclosures. Not on
I agree.
guys in the net. Not on
Okay.
guys in the net.
Well, real quick, I'm about to say this is gonna be something that I don't mind telling y'all. If you do want to do that, first step that you must do is get your contract for any creditor that you have. You have to get your payment agreement, and we have to review your payment agreement. And then you have to get the coupon voucher. It is best to get the paper part that you tear off. Some people be trying to do it online and don't always work for them. Get the bill with the part that says it's a coupon with the perforated line that you can rip off, because
Oh, yeah.
that is the part that they request that you send in with your payment agreement. You, for some reason, y'all just never send it in. It says always send it in with your payment. Even if you send an electronic payment, they still want the coupon. You got to do it.
Right. Oh, I didn't tell you, did I?
Wait,
My.
just wait, because you.
Oh, okay. I had
I
something
don't
to
want to
tell
have no
you.
coupon talk right now.
I had something to tell you though. It was real important. You gotta holler at me after this class.
Bro, go
Huh?
tell the class. Share with the class. Share with the class.
Man, I don't know if I told you that my sister, my sister baby daddy, other baby mama, right? Well, she was listening to my sister, right? And they thought that remember I told you that she did that her car was supposed to be paid off?
Yeah.
Yeah, it backfired. They came back to holler at her about that
Oh,
and
so
told
now
her
she
no.
understanding what I'm saying. So, what does your sister do? A 1099 or what she do?
I don't know what she did with her baby daddy,
E-
baby mama, but it
Either
was
she
something about
did
online. Maybe I think it was a 1099. Matter of
it was
fact.
either I think she was doing a 1099 or she took the social security numbers and route numbers and she attempted to pay for a transaction. That's not the way you do that. In the payment agreement for every contract, they tell you how they accept payments, fam. And matter of fact, I'm about to show y'all this picture just so y'all can see one. And this is from one of my partners. Some of y'all know her, but I'm about to show y'all this testimony. I think I shared this with you, Riley. Let me see.
About the bill, they sent her a check.
No, that's different. I don't know if that's too blurry. Can y'all see that? Hell no. I can't. I'm about to have to send it to myself because it's the camera not showing. Let me send it because I want y'all to be able to see this real quick.
Hey, bro, I was laughing so hard.
Why
I
would you do that to them people?
Oh, I ain't do that to them. I told.
Why you gonna laugh at them? It's not you laughing at them people pain. That's not fine, bro.
Nah, hell nah. 'Cause I told her, I said, hey, man, they lucky they had their ass in jail somewhere playing with them damn people money like that. I told them, man, you can't just be on here listening to Christopher Hauser, man. You better let that man go. He gonna
Yeah.
have your. Matter of fact, I gave her the. You was like, remember you was like, do a mice or a rat know that they been a test subject? She
Oh,
was like, no. I was like, well, all right, here you go with you and Chris Flowers. He don't know. You just got your ass on here looking. Man, that shit was.
hold
It was
on, bro. I'm
crazy.
about to Let me show this window. Okay. So this right here, this from one of the homies. Let me open that. Okay, y'all see this, right? This is an American Express. And right here, it says adjust your payment option to reflect a dispute amount. And then it said $1,072.42. Dispute balance, they owe zero, they owe zero. This was paid off with a coupon. This is actually from one of Goody people. So like we be sharing testimonies with each other, and I show her my injunction testimonies, I show her the credit letter testimonies, and we just share what you said. Can I unmute you? Yes, ma'am. I didn't know you were muted. You got two up here. Hold on. Can you say something, Miss Bill?
Yes, can you hear me now? I've been trying to talk the whole session.
You kept on dropping off. I didn't even know that you had dropped out.
Yes, so regarding the coupon issue, I I sent it back to Citibank, but I think do you supposed to calculate the interest for the daily balance, or do you just send it in blank?
No. You for sure have to put the right payment amount on there, and interest is part of that, depending on the timetable. And sometimes it's best just to call them and get the exact amount, but you do have to put that on there.
Okay, so I
And you have
did
to mail
call
it to
one
the
of the
right address.
representatives and she wouldn't give me the amount. So I tried calculating it myself based on, I only had like a couple of transactions. So I added in the interest from the agreement and I sent it to the express mailing address on the agreement. And I didn't get a response at all. All I got was them sending me another email saying make the minimum payment. So I did something wrong and I don't know what it was.
Did you send it certified mail or anything? Can you track and confirm that they received it?
Yes, they got it. I sent it on Thursday 2 weeks ago. They got it that Friday.
Okay, they got it that Friday. It still hasn't been processed, so something was wrong with it.
No. I don't know if anything was wrong because one of the
No, I'm gonna tell you that if you read the payment agreement, the moment they get the instrument, they usually credit your stuff within 48 hours.
Exactly. They said up to 5 days on my agreement.
Okay, it's been over 5 days, right?
Yeah, it was like the next Wednesday. So I just went on and paid minimum payment because I'm like, I did something wrong.
So what you need to call up there and be like, there has been a billing error dispute. I ended up paying twice. You all received the instrument from me, and I just wanted to confirm if the instrument was proper because now I ended up having to pay you again, and I haven't been returned the instrument. You don't got to say none of that extra crazy stuff. Just be like, you could tell them it was a check. They don't know the difference. Hell.
Can you repeat that one more time, please?
All right, so when you call them, you just gonna pretty much tell them that you have paid twice. There's a billing error. It was a billing error, and you ended up paying twice. And you had sent another instrument, and they didn't credit it to your account, and you were trying to see if they received it. And if they received it, you would like to know why it wasn't processed. You understand? You hear the language?
Yes.
Okay, and you should have access to this recording. So if you remember, we at like 127 today. So you can come back to this time and you can play that part back if you don't remember.
Got you. I appreciate that.
Not a problem. Anybody else?
So am I doing it right by calculating the interest? I don't send it in blank, correct?
Yes, but I just don't know if your calculations are proper because it could be off by a couple cents, and that'd be the reason they don't want to accept it.
And you know what? It was so crazy. Let me just ask you this one question. Okay, so on my commercial lot, it had that the due date. No, it had that a transaction. It had that my last month payment was on the 15th. But when I called them, they said because I paid it after 5 o'clock, it was credited on the 16th. So I made the interest payments based on the 16th, what she told me over the phone.
Oh, you got hit because you missed the date interest. They ain't run your stuff. Oh my God. That's crazy. That probably did happen.
So that's what I'm like, man.
That's really possible. That's possible.
So I should have did it based on the 15th, what was on the commercial unit, correct? Instead of going by what she said on the phone that it didn't post till the 16th. Because that's what I calculated my interest on.
If it didn't post on the 16th, it depends on because banking hours, if they didn't process it in the system to the next day, they possibly would have added more interest on and you could have been off by a day interest.
Exactly. So now I gotta wait till the next one come in the mail. I got it though. I got it.
Yeah, that's wild. I
So
never even
now
thought about that
I
happening
won't.
to nobody.
Yeah, I won't pay. I have to pay my bills, in the morning. Now I can't let that happen again because that just took me off guard. I was like, what? Okay, that was it. Thanks.
Yes, ma'am. Anybody else? Anybody else? I'm gonna say that sound like you, Riley. It sound like you got something to say.
Oh
Well,
yeah, you know what?
see, I already
It's
know. I just knew it was you.
it's pertaining to trust, right? It's like it's a different type of trust, like a oh my god, it's like the family, not resort. What word am I looking for? It's like the
Real estate.
nationality,
You're talking about a tribal trust?
right? The tribal trust.
What about it?
How much does that one cost?
You need to do your genealogy before I can do a tribal trust for you, because I need to know what tribe you belong to.
That's what I'm saying.
What
I wonder
What are
who I.
you saying? You didn't say that. What are you saying?
Nah. I was out in my head, cause like my mama Jones. I think we some type of cousins on down the line somewhere. I'm trying to tell you something
Hey, this
good.
guy.
My mama said I had some family up in Detroit, man. I'm trying, bro. That's my word, bro. I got family in Detroit. Like up top, I got a family coming from there, and I think you're one of my cousins.
I hear you, bro. I hear you.
That's my word.
You got to do your genealogy that way that we can make sure, because I can make you documents for anything, but what can you prove that you are actually bloodline attached to so that you can get the proper benefits? Because same way how my family got certain treaties and stuff that they got ties to, yours do too. You just want to make sure that you putting yourself in the right position, bro.
Right. And that's what I was trying to tell your homegirl as well, which is my sister. I'm like, you gotta do like we gotta get the tribe, which is like, no, we don't need no paperwork. I said, all right,
Hey,
Chris. All right, Chris. I done told you about Chris. Well, back off Chris now.
outside of European white males and corporations, American Indians is the only other entity that's mentioned in the 14th Amendment. And part of the Supremacy Clause of the United States Constitution, Article 6, Clause 2, it says that treaty is the supreme law of the land. So, per the United States Constitution, treaties are established with indigenous people. So, who has the rule of the land? Regardless of whatever people may project right now, per them people's documents, that's what it say. And that's one of the main reasons why I kind of do what I want on a day-to-day basis, because I know that law.
Right.
And I don't
And they
have
got a direct trust with your family.
yeah. I'm not bothering nobody. I'm just conducting my business. And you asked if I teach genealogy. I help people do their initial setup, and I guide them through the steps. Genealogy can become time consuming, but I help people set it up. I tell you the steps you need, the platforms to use, and I also help you to create the connections. And all you have to do is just let time work with the algorithm, and then you'll start getting connections. So I help people to get to that point, because it's very difficult to be in a position to build family wealth and you talk about your future and you don't know where your family came from, because then you consistently are spiraling down identity crisis and other people's lifestyles versus what your family established for you and for your children and your future generations. Like, genealogy is one of the main ways in order to save your sanity. I promise you,
Man.
whether if it's you have an African American, a Black Pan Africanist mindset, or if you just may not know what it is, whether if it's Christian religious identities, we identify with all of these other things outside of self. And don't get it wrong, I'm an ordained minister and all these things. We identify with all of these other things because we are lacking a sense of self, because we have been purposely miseducated to disattach us from this land, which a lot of us actually come from. Because if you know you control the land, and we just read in the very beginning section, Chancellery Court, Land Court, Equity, Just and Fair. If you're not in a position of just and fairness, you fall in a position of commerce, statute, and codes. And people who fall in that, they always get mistreated, because that's not a just and fair system. if you were in a just and fair system as being a landowner, being a trustee or a beneficiary, as what we are initially are, when you are not subject to a subclass, it changes the dynamic that the United States has to deal with you. And that's one of the main reasons why I do have paperwork, because I don't want it to be any assumption. And if it is, because ignorance of the law is no excuse, regardless of who you are, I put all these things on notice. So if you have a trespass against me, or if there's a tort, it's an issue, I have every right to sue you. So it's just better to have all that stuff in place, fam.
Right, right. That's what I told my sister.
Central Americans, you said if your ancestors from Central Americans, so I deal with a lot of Taino and Arawak and people from the islands. Those are still indigenous Americas. America is not what the United States is. America is the Americas. That include Canada, all of North, the South, Central. It's been indigenous people going up and down. So if your family is from here, you're still considered an American Indian. It's not the United States American Indians. It's American Indian. All of the Americas, bro. So if that's the case for you, you still are an indigenous American, and you just your family may have not came from this specific region, but you still are entitled to American or rights of indigenous people rights, Aboriginal rights by law.
That's what I'm talking about. You just gotta have it on paper. I try to tell her.
What he said, if you private trust, if you can provide evidence that your grandmother is Cherokee, you can create the documentation in order to attach yourself and the rest of your family to that per bloodline. And all you have to do is just the same way how to record a trust, you record all that information in the court. And we get exemplified copies. Exemplified copies are judge signed copies. So all of our tribal information, I got judge signatures all across it. So they acknowledge everything is true.
But
Miss Bill, how do we hold on a second, Riley? Miss Bill, how do we find what? How do we find that out? You mean as far as genealogy? You can go to ancestry.com. You need to know your parents, both your parents and your mom maiden name, and you need to know all four of your grandparents and the women's maiden names. And that's really all you need to start. And you build out your family tree. No DNA test involved. Don't give nobody no DNA. You don't need that in order to see who slept with who in order for you to get here.
right. On my daddy's side, I never met my grandfather, as well on my mama's side either.
Now, I mean, your daddy don't know his daddy name, bro.
Oh no. My daddy know his daddy. He died when
I know. So all you gotta do is ask your daddy his daddy name. That's all you need.
Okay. That's sad I don't know my granddaddy name. Because
Yeah.
my other granddaddy that my grandma had married stepped in.
You gotta, it's more common than you think. I say this to a lot of people because most of us don't know our great grandparents, let alone our 10th great grandparents. I can go back and tell you all of my 10th great grandparents. I have the records, but that was something that I worked for. But the benefit of that goes beyond just me knowing, because I found out information. Do you know how good it feels to, like tell your little people, your children, like, you have to act right. It's statues of your grandparents out here, fam. So it's like we come from this group of people. Being able to identify and truly know this is who your family is, it is. I don't identify with a lot of the BS going in the world because I know, like, that's not my group of people. And
Right.
I'm okay with that because, like, no, I'm like, that's what y'all want to do. And I just know our family and our situation is different. And when you understand that, you won't feel the need to, you can empathize with people, but am I going to put myself in that, like, actually physically going to put myself in that situation? No, not at all, because there's no need, because I have protections now, because I know better.
Right. I know who my family is.
You got tribal land in Louisiana. That's probably like in the Shreveport area. So if they are from the Louisiana area, if you know any of the tribes, you just have to know a little bit more about the city. It's a few tribes like out in the Shreveport area, so we can see the year that she was alive and pull the rolls from those years and see if her name was on the rolls, and that's the easiest way to do it. So we good?
We good.
All right. So for those of y'all who, there's only a few of y'all who are in the highest tier, I will see you all tomorrow. Outside of that, podcast releases on Tuesday. Next class that we'll probably end up having will be on Wednesday. I have to check the calendar. And if y'all have any questions or if it's anything that you want to talk about, drop it in the chat. I'll piece together the information. Oh, that is right. The next class that I'm having is going to be for tax deeds, tax liens, because it was a young lady who actually wanted to go over those classes. So I was fortunate enough to buy a property for like $200 back in Detroit. In total, the bidding price was $1,000. I paid $200 for it, so $1,200 total for a 2-family flat. I'm going to show y'all how I was able to do that and how you can do that in your same city, like literally grabbing property for a few $100s. And then this is what we call asset acquisition. And when we do the acquisition, we make sure we put it directly into the trust. So now we're creating value. We have assets. We go open up a bank account. And then we walk into the bank account. We show them our asset ledger. And they be like, you want some money? Be like, yeah, what's your credit? I'm not here for credit. You don't have to run my credit. Here's my assets. And this is what I want to work with. And then they will put you in a position to collateralize land. Yes. Thank you. I appreciate all of you all for coming out. I appreciate y'all for supporting whatever it is we got going on. If y'all got any businesses, anything, let me know. Drop them in the community so I can support you and I can have other people support you. Also, if you want to be on the podcast, let me know. I'm always down to have new guests. So just like I said, hit me up, fam. Thank you. I'm so happy that y'all appreciated the class, fam. I'm thankful. Well, peace and love. Y'all have a great rest of y'all evening.
Peace and love, bro.